Good morning, ladies and gentlemen. My name is Agata Wróbel, and on the one hand, I'm affiliated academically with Cardinal Stefan Wyszyński University in Warsaw, and on the other hand, I have the honor to co-organizing today's event on behalf of the Institute of Justice in Warsaw. So I have this pleasure to moderating today's opening panel and the first panel of our conference. So I officially welcome you to today's conference on legal issues related to migration. And I warmly welcome all the speakers as well as all members of the scientific committee who have accepted our invitation. We are very pleased, so thank you. And we will start the meeting with a recording from Professor Marcin Wielc, as he is head of the Institute of Justice in Warsaw, as well as head of criminal procedure and vice dean of Faculty of Law and Administration at the Cardinal Stefan Wyszyński University in Warsaw, and the head of the research group Migration Challenges, Legal Responses in Central European Professors Network 2023. Coordinated by the Central European Academy. Unfortunately, work obligations didn't allow him to be with us today, but he made sure to greet all of you with good words in the form of a record. I need just 1 minute to play this video.
Dear sirs, my name is Marcin Wielc. I'm the Deputy Dean of the Faculty of Law and Administration at Cardinal Stefan Wyszyński University in Warsaw, head of the Chair of Criminal Procedure at this university and director of the Institute of Justice in Warsaw. In addition, today I'm appearing before you as the head of the professors group Migration Challenges, Legal Responses, in which we are conducting research as part of the Central European Professors Network project coordinated by the Central European Academy. At the outset, I would like to offer my sincere apologies for not being able to attend this event in person. Unfortunately, professional obligations have prevented me from doing so. Nevertheless, I believe that we will soon have the opportunity to debate on another occasion. I would like to extend a warm welcome to you to disseminating event of PhD Bartlomiej Oręziak International Academic Conference, Legal Responses of Migration Challenges, View of Young Researchers. The event is organized as a part of the Central European Professors Network, coordinated in what I mentioned, Central European Academy. That event is also under the honorary patronage of the Department of Criminal Procedure of the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. I warmly welcome members of the professionals groups, members of the scientific committee, speakers, students, and invited guests to this momentous scientific event. The conference will focus on various issues related to migration and its legal and social consequences. Topics to be addressed include the structure of migration-related crimes, observation on human trafficking, the competencies and responsibilities of European Union member states in border management within the context of migration, the fundamental principle of non-refoulement in the context of the European Court of Human Rights, jurisprudence, the religious consequences of migration, the role of the border guard in combating migration related crimes, issues concerning the freedom of movement for workers within the European Union, the perspective of Polish criminal law concerning illegal border crossing, as well as the challenges associated with illegal migration and human trafficking in the European Union. Given the current socio-political circumstances and events we are witnessing, as well as the challenges facing countries and the European Union, the topic identified are of great importance. Illegal migration has been a problem in Europe for years, both for individual countries and for the European community as a whole. Importantly, it has been unable to cope with this challenge for years, which has an impact on the security of citizens and the realization of human rights and freedoms. I believe that the scientific debate at the highest level will allow us to develop the lege ferenda conclusions, which will contribute to changes in both national and international migration and refugee law. In addition to eminent experts of European stature, theoretical and practitioners from Central European countries, our event is also attended by young researchers. It is very important for young people to have room for action and to be able to develop themselves internationally so as to lay the foundation for future cooperation. Once again, thank you very much for your participation and presence at the event, and I wish you fruitful deliberation.
I thank the professor for the video, and now I would like to give the floor to Dr. Bartlomiej Oręziak. Please, the floor is yours.
So, ladies and gentlemen, it's my pleasure that I kindly welcome you to our international scientific conference entitled Legal Responses of Migration Challenges of Young Researchers in 2023. And of course, I would like also to thank Professor Wielc very much for his opening speech. This is a great honor for me. Thank you very much. And as you already know, my name is Bartlomiej Oręziak, and I'm a member of the Central European Professors Network 2023, exactly in the research group Migration Challenges, Legal Responses, headed by Professor Marcin Wielc. And it is a real honor for me that I can open this conference, as this is my dissemination event in this project, the project Central European Professors Network 2023, where so many scientists will have the opportunity to present their thoughts. And to be honest, I have to say that I am more than happy that this is third edition of this conference. So we have here some new tradition. In 2021, it was International Scientific Conference entitled The Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism of Young Researchers. And in 2022, it was an International Scientific Conference, The Right to Privacy of Young Researchers. But back to 2023, I want to thank all the speakers for participating in today's important event. It's great that you agree to show us your presentations. I would like to emphasize that the event is organized as a part of the Central European Professors Network, coordinated by the Central European Academy. The event is held under the honorary patronage also of the Department of Criminal Procedure of the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. Ladies and gentlemen, I would like also to thank the scientific committee. I would like to emphasize that as the international conference, we are dealing here with extraordinary experts. This is Professor Wielc from Poland, Professor Davor Derenczynowicz from Croatia, Professor Paweł Sobczyk from Poland, Professor Szilagi Janos Ede from Hungary, Professor Christian Miches from Romania, Professor Timea Barzo from Hungary, Professor Zombory Katarzyna, also from Hungary, Professor Frane Stanicic from Croatia, Professor Erika Czemane Varadi from Hungary, Professor Nora Beres also from Hungary, Professor Dalibor Dukic from Serbia, Professor Samo Bardubski from Slovenia, and Professor Gregor Małcec from Slovenia. Professor Katarina Szmigowa from Slovakia, Professor Ludmiła Elbert from Slovakia also, Professor Fabian Julia from Romania, Professor Katarina Frumarowa from Czech Republic, Professor Dawid Szechnalek also from Czech Republic, and Dr. PhD Mateusz Tchórzewski from Poland. Thank you very much for great accept the invitation to the scientific committee. And last but not least, I would like to thank Agata Wróbel for her great organizational support. To be honest, Agata, without you, this event would not be the same. I wish everyone successful deliberations at the conference, successful presentation, and best of luck that we have the opportunity to meet in a wide international group. Thank you so much.
Thank you very much, Bartłomiej, for your speech. So now let's move on to the first panel, which I'm really excited about. So as the first speaker, I would like to invite Professor Christian Miches with the speech Observations on the Offense of Trafficking in Human Beings Criminalized by the Penal Code in Romania. Please, the floor is yours.
Dzień dobry. Thank you very much for the invitation, and good morning to you all. I am very honored to open this conference. It's really a pleasure and an honor in the same time. I thank once again the organizers, and also, because I see her in the screen, Professor Erika Baradicema from Miskolc, who is, let's say, one of our dearest friends also. I will try to project to share the screen. You can see it. It's okay. Can you see the screen?
Yes, we can see your presentation, Professor.
Okay, thank you very much. I will start, and I tried to fit in the 10 minutes period. There are a lot of things when we are dealing with the migration phenomenon. And I start very abruptly from one point of view, in the sense that I have to address the difference between human trafficking and migrant trafficking. Although even in criminal law, these concepts are treated as one or in the same provision, we have to take into consideration what are the differences between those two phenomena on one hand, and if there are differences, then we should look also into the criminal law side. Anyway, both of them are flagrant violation of human rights, and they impact on the dignity and integrity of the human being, as well as against the individual's security and social and moral values. As regarding the difference, as pointed out in the United Nations Office on Drugs and Crime, first we are looking to the consent, while in case of migrant trafficking, the consent is required, and we have the consent in some form, even a valid consent sometimes. In trafficking of human beings and when victims are especially women and children, there is a lack of consent, or even if the consent initially existed, is later defeated as a result of misleading, abuse, and violent methods used by the traffickers. On the other hand, is the exploitation. The traffic of migrants ends when they reach their destination, while the human trafficking involves a permanent exploitation of the victims. Transnational nature is also important to look into. Migrant trafficking is always transnational, while human trafficking may not be transnational. And as regarding the source of profit, the profit is the result of securing the transport or illegal entry into a country, while in case of human trafficking, the profit is the result of the exploitation of the victims. Why do we have such large-scale phenomenon? I have tried to summarize and point out a few of the let's say causes, the few of the things that do generate human trafficking. First of all, armed conflicts. I refer to former Yugoslavia and also to the conflict in Ukraine, since they are in Europe. And I dare to say that while, as regarding former Yugoslavia, from my point of view at least, the things were very, very, very bad. I'm not saying that now, as regarding Ukraine, are not bad, but as regarding human trafficking and migrant trafficking, it is my humble opinion that in the last one, in the conflict regarding the Ukraine, there was a more human approach was implemented. A more human approach was implemented by the European countries. I mean, we received the migrants, we received them well, we granted a lot of facilities to them on one hand, and on the other hand, this generates less human trafficking, because when you take care of the people who do not have any more a house or a job, or they are under the shell, the constant shelling, then you take, let's say, if I may, the object of the human traffickers. You take away that object. The other cause, that generates human trafficking is the effect of the transition. If we are looking Southeast Europe, East Europe, Middle Asia, and so on, corruption is a very, very, very important cause. The weak control of the borders, of course, the legislative framework, and not really that we do not have the laws, but the problem is with enforcing the laws. On the other hand, the restrictive condition regarding the migration in the country where there are more developed situations, more developed economy, can also generate human trafficking. And last but not least, the internationalization of the criminal groups as a result of globalization. We have to take it also into consideration when we're looking to this phenomenon. As regarding more concretely to our Romanian regulations, we had a special law transposed in European directive, but since 2014, in the not so new now criminal code, we have a chapter dedicated to trafficking and exploitation of vulnerable persons. This chapter does not regulate only trafficking in persons as well as trafficking of minors, but also refers to the other forms that are more, let's say, connected to the migration. I mean, slavery, submission to forced and compulsory labor, pimping, exploitation of begging, using a minor for begging purposes, using the service of an exploited person, and very recently, newly introduced, the use of child prostitution. I will refer a little only to those two trafficking criminal offenses. I did put a project on the screen, the text we have now, the last form of it in the criminal code. Unfortunately, although we had rather new criminal codes, as discussed with my colleagues from Warsaw and from other countries, from Hungary, in the conference in Budapest last year, our code did suffer a lot of changes, which is not really very good for the stability of the justice. I took the liberty to underline a few things about trafficking in persons. I mean, we have alternative conducts: recruiting, transporting, transferring, harboring, or even receiving a person to the purpose of exploiting him or her. And on the first letter, A letter, I have underlined misleading. Misleading means that the perpetrator uses means that can obtain, through he or she can obtain the consent, even the consent of the victim, by showing or depicting some ideal situation, what would be reached, let's say, when she or him will reach the destination. On the other hand, there are also very serious situations when we have the impossibility of the victim to defend herself or himself, or to express one's will, or we have the state of obvious vulnerability of that person. In these cases, the victim, even if will try to respond to the proposal of the perpetrator, she or he will not be able to resist, either from subjective point of view, either from objective point of view, will not be able to resist to the offer. If we are looking to the final paragraph, we have to see that the consent of the person, as in all other criminal offenses, the consent of the person in this case, of a person who is victim of trafficking, does not constitute a justifiable cause. That means, as an exception for the general rule, when the consent of the victim may or may be not, but in many cases it may constitute a justifiable cause, and the effect is that we do not have a criminal offense. In this case, the legislator, taking into consideration the methods obtaining the consent, said that the consent of this kind of victims cannot be taken into consideration as to waive the criminal responsibility of the traffickers. When we are talking about traffic of minors, the legislator, I think, in good faith and in good mind, thought that we need a special regulation to address this matter. And we have a dedicated article 211, trafficking of minors. And besides what we had before, as regarding the alternatives of perpetrating, the consent, the lack of consent, or let's say the presence of the felony, the criminal offense, even if there is a consent of the victim. In this case, it's more obvious that a minor, a person underage, that means under 18 years old, even if he or she gives her consent, then we cannot use this consent. We have to waive the criminal responsibility of the perpetrator. But we have new circumstances, as letter C, when the act endangers the minor's life, one hand. That means that his life is put under threat. And unfortunately, we have to introduce also letter D, which is very sad that we had to introduce, but that is the situation. The situation in the field did confirm that many of these crimes were perpetrated by family members, or, as regarding letter E, persons who have a moral ascendance on the minors. Persons who would have been were entitled to take care of the minors, to educate the minors, or I don't know, any situation in which they situated, let's say, with a moral ascendance on the minors. So we had to take this in consideration and regulate as such as an aggravated form of trafficking of minors. And also in the general part, we have a determination of a meaning. What means exploitation of a person, either submission to execution of a job, or being kept in a state of slavery, or forcing to practice some kind of conduct, or begging, or probably more seriously, illegally taking organs, tissues, and or cells of human origin. What can we do? because the phenomenon is ongoing, developing. I try to address two aspects from two points of view. We have the National Agency Against Trafficking Person, agency who is not so active from my point of view yet. I hope in the future it will be more active. But nowadays they try to set up an application, an app, Bright Sky Row, which can, let's say, offer some extent some kind of help. I mean, what does Bright Sky offer? A relationship security assessment questionnaire as regarding to the lover boy method. Lover boy method, when the perpetrator makes the victim fall in love with him, for example. Confidential diary of documents signed in domestic abuse in text, picture, video, audio format. Resources, tools, and information on domestic violence, harassment, and sexual abuse that can generate finally, or in the end, human trafficking. An online safety guide with tips that can help increase your or the victim level of security, and contact details. On the other hand, we have a rather new from this summer project, LUPTA, it's called. It's abbreviation, leading a united pathway against to anti-traffic action. On the right part of the screen, I think in your case, we have the chart out with the cases recorded in 2020, 21, and 22, conviction, prosecutions, and with the darkest blue investigated. You see that there is a difference, of course, between the investigated cases, prosecuted cases, and with the number of conviction. This toolkit issued to the purpose of let's say, investigating better, trialing better, and offering what a victim should have. I mean, a victim, we cannot look at the victims of human trafficking from only one perspective, only from the law or criminal law perspective. We have to have we take into consideration that there is a trust-based offense. So there is a breach of trust. When we are talking with a breach of trust, then the whole universe of that person can fall. So we have to have a holistic approach, a victim-centered intervention. We have to have tailored techniques. We have to have and discuss and effectively have social reintegration, both to the victims and the perpetrators, because we cannot address only the victims or only the perpetrators. We have to have adequate witness protection, and of course, special attention to minors. Ladies and gentlemen, dear colleagues, this was an insight of what can or picture, let's say a picture or a quick picture of what does it mean human trafficking in Romania as regarding the regulation and as regarding the practice. It is very difficult for us to tackle this phenomenon, and on the other hand, we have to take into consideration that since it is a global phenomenon, international phenomenon, we should have also an international response. Thank you very much. Thank you.
Thank you very much, Professor, for all observations. And now we'll give the floor to Professor Katarina Frumarowa with the answer to the question, the concept of safe country of origin in the legal order and practice of Czech Republic. Are exceptions permissible? And now I will give you presentations. Because you said
Yes, thank you very much.
Okay, now you can change it by yourself, by now.
Yeah, thank you very much. Thank you very much for the opportunity to be here with you and to tell you something about the situation in the Czech Republic. I would like to focus on the question of the so-called safe country of origin because it's a quite key institute of asylum law, not only in the Czech Republic but also in the world. This conception or legal construction means that a state does not grant a person international protection and moves this person to another state that is safe for him or her. This concept is used all around the world, including Europe and European Union, and it's connected with the migration crisis. Its origin. It's connected with the migration crisis in 2015 in Europe. Very important institute connected with this safe country of origin is also the Institute of Effective Protection, because the state must be able to give a person this kind of protection. There is no legal definition, but on this slide you can see the most important characteristics of this institute. For example, the applicant is not at risk of refoulement in a third country. This third country must respect the rights of the applicants, guaranteed not only by European Convention but also by other international or regional instruments. The third country should be a party of a Geneva Convention and so on. Now to the safe country of origin from the point of view from especially EU law and also the Czech legal order. This institute also serves to speed up the asylum procedure, and it has quite strong consequences in the procedure. I will tell a bit later. What does it mean, the safe country? We can find also in the EU law, but also the Czech law, especially the Asylum Act defines the concept of a safe country of origin. So we have something like a guideline how to interpret this institute in practice. What is very important is that the EU law, the procedural directive, does not contain a list, especially for political reasons, a list of states that can be considered as safe countries of origin. But many European countries have their own national lists of countries that they are considered to be safe countries of origin. And also our state, the Czech Republic, has used this option by Article 37 of the directive, and the list of safe countries was issued by the Ministry of Interior of the Czech Republic. It's a decree number 3028 from the year 2050, and a very important condition connected with this list is also that at least once a year this ministry must review this list. And if it is possible, it must make some changes. What is very important is that the Czech Republic applies some, we can say, exceptions from this concept, because 3 of these countries on this list that are considered to be the safe country are not safe as a whole. So the Czech Republic say that safe country is Georgia, but with the exception of Abkhazia and South Ossetia. The same is Moldova, but with the exception of Transnistria. And the last example is Ukraine, with the exception of Crimean Peninsula and the regions of Donetsk and Luhansk, which are under the control of pro-Russian separatists. But however, in practice, since the beginning of the war, the whole Ukraine is no longer considered as a safe country. We can say that these are something like territorial exceptions from the concept of a safe country. It's not unique because, for example, the Czech Republic, Denmark, and Finland designate Georgia as a safe country of origin with the same exception as I said, or Cyprus, and again Czech Republic applies the exception for Ukraine, and for example Hungary designates the US as a safe country, but only in relation to states which don't apply the death penalty. Also, we can say that not only territorial, but also, I skip it. Also, personal exception are appeared in some lists. For example, Luxembourg has designated Benin and Ghana as a safe country, but only for men, not for women. In case of Russia, Denmark applies exceptions for ethnic Chechens, LGBT communities, Russian Jews, and also for all politically active persons who are faced abuse by political or public authorities. Also, for example, Netherlands has exception for specific groups of people in Armenia, Morocco, and Tunisia. What's the legal background for these exceptions? If we see the previous regulations, it was Council Directive from 2005. So this directive expressly provided for the possibility of exceptions, both territorial and personal, but it was repealed by the current directive from 2013. This directive no longer explicitly regulates this option, and if we read the preparatory work for this directive, it's clear that the legislator intentionally removed the possibility of territorial or personal exceptions. So it's quite clear that the idea was that the country should be safe as a whole, and the exceptions are not welcome. Why? The concept of a safe country is also connected with some procedures specifics which are connected with more speed procedure, because the member states are not obliged to decide on merits if the applicants comes from the safe country of origin. And it's the principle of the so-called accelerated procedure. On the other hand, the applicants are guaranteed the opportunity to participate in the procedure, and everyone can present some serious reasons why his or her country of origin cannot be considered safe in his or her own case. But it's on the applicant. He or she must demonstrate that she or he is at a greater risk of persecution or of some serious harm than others in a similar position. Yeah. So the question is exceptions, yes or no. I think that this conception of exceptions has more disadvantages than advantages, because the admission of especially territorial exceptions distort the decision-making body's approach to assessing applications for international protection of applicants from the same country. Some applicants from the same country are in different procedural situation or position than the others, because they must rebut the presumption of the safety of his country of origin. And I think that the legislator, the EU, wanted to prevent this situation and these differences between citizens of the same country. Moreover, the other critics connected with this concept or with this exception is that they lead to stereotyping and to prejudice against applicants from the safe country, because everyone think that if the country is safe, then no refugees can be produced by such a country. And the other question is some limits or borders of this exception. Is the exception also when maybe the majority of country is not safe, or how big should be the part of country for the exception? So these are other questions which can be discussed in this issues. So other disadvantage is also that this concept of exceptions leads to maybe something like discrimination, because, as I said, these persons are in a much more harder situation during the procedure. But on the other hand, there are also voices that this directive from 2013 does not absolutely exclude exceptions. So it's question if the exception should be or not, or what are the solutions or conclusions to this issue. In my opinion, I think that the exceptions, both territorial and personal, but especially territorial, should be cancelled and not be applied in practice. As I said, we have more disadvantages than advantages in this issue. Also, the Czech Republic is aware from the situation, and we try to solve it because the Ministry of Interior of the Czech Republic prepare to change this checklist, and the ministry intent is to cancel this free exception that Czech Republic still has. And very important, and it's my final couple of words, is that also the Czech
I think that it's some technical problem. I can't see Professor with us. I think she's out of the meeting now. So that was conclusion. So I think that we can move forward, and if Professor will come back to us, she will finish her presentation if she would like to. So now I would very much like to ask to give the floor to Professor Dawid Szeknalek with the speech, The Migration Crisis, Compliance with the Law That Cannot Be Complied with, and the Czech Republic. Please, the floor is yours. I'm sorry, but I cannot hear you. I don't know how about the other participants. Seems to be a problem still. I think that maybe you should close the meeting and come to us secondly. That may help. Okay, I have a message from Professor Szechnalek. We'll pass the voice to next speaker, and he will try to solve technical problems. So now I would like to ask Professor Ludmila Albert to give her presentation.
Thank you very much for a word, but I think that there is a problem to share my presentation.
Yes, because Professor Szechnalek is still sharing his screen. Oh,
maybe it's now. It will be good. I will try to share my presentation. Okay, can you see it now?
Yes, we do.
Okay, thank you very much. So, thank you very much for the word, dear colleagues, dear professors. It is my pleasure to pleasure my ideas during this conference, which I attend as a part of the research project, as Dr. Bartlomiej Oręziak already mentioned, the Central European Professors Network, which is supported by the Central European Academy. And this is my dissemination event within this project. So before I start, I would like to thank Dr. Bartlomiej Oręziak that I can be here as a presenter. My topic is migration challenges in Slovakia. It is dedicated to Slovakia, as I am a member of the Institute of International Law and European Law of the Faculty of Law, Pavel Jozef Šafárik University in Košice, Slovakia. And when I was thinking about the migration challenges in Slovakia, I was trying to pick up two main issues that I will present today. So the first is the issue of detention, because it is we are dealing with the issues with detention for the longer time, and the second one, remaining in the Slovakian Republic territory. It is much more current issue, maybe more political issue, as we are approaching our elections in Slovakia. So let me start with the detention. Detention and procedure of detention is influenced by the status of the person, even if it's the ordinary third country national, or is it the asylum seeker. The detention procedure is governed by our Act on Residence of Foreigners, which governs the conditions of the detention of the third country nationals, especially the detention conditions of the asylum seekers, and also alternatives to detention and rights and obligations of the police department, as well as the third country national. But the practice of the police department within the procedure of the detention is not always in accordance with this Act on Residence of Foreigners. So we have a couple of judicial reviews by the county courts or Supreme Court or even Constitutional Court of the Slovak Republic. These cases are mainly in relation to detention of asylum seekers, as they have different and and the special conditions for detention, which should be followed, of course. And we have two issues. The first issue is redetention of the person with the status of the asylum seeker, and the second one is the issue of reasoning of detention decisions. So on two cases, I would like to show you the evolution of the police detention practice. The first case is the judgment of the County Court Košice in 2019, which was about the review of detention decision of the police department, where the claimant, it was about the claimant who during the detention procedure became applicant for the asylum. It was the detention for the time necessary to execute the decision of administrative expulsion based on reasonable suspicion that the applicant applied for the asylum only with the intention in order to delay or frustrate his administrative expulsion based on his previous illegal stay in the territory of the Slovak Republic. So the county court issued the judgment about the annulment of the contested decision of the detention. And on the ground of the such annulment of the first decision of the police department, the claimant was physically taken out from the detention facility, where the police officers reversed him and took back to the detention facility in order to hearing and to impose new detention decision. But in that time, the claimant was already in the position of the asylum seeker. So the police department based its second detention decision on the grounds of the first detention, when the claimant was detained as a foreigner without the permission to enter or stay on the territory of Slovak Republic. So it was the decision based on the wrong factual situation. And the other, or the second case is the case before the Constitutional Court of the Slovak Republic. It was the case where the detention decision was issued based on the information of the Slovak Information Service. The detention was decided for the necessity due to threat to national security or public order. But such detention decision has lack of clarity and vagueness. There was no assessment of the detention reasons, and also the reference to the nature of the classified information with the level restricted was not sufficient. So the Constitutional Court of the Slovak Republic decided that such detention decision violated the basic rights, especially the right to liberty and security of the person, according to Constitution of the Slovak Republic, as well as the European Convention for the Protection of Human Rights and Fundamental Freedoms. But nowadays, the time has changed, and in Slovakia, as we look at the history, the highest numbers of the irregular migration in relation to Slovak Republic represents not illegal crossing of the border of the Slovak Republic, but unlawful presence at its territory. So nowadays, we are witnessing the massive migration flow from the Middle East, especially from Syria to Western Europe. But still, Slovakia is just the transit country. But the main issue nowadays is the written confirmation to remain in Slovak territory, which is granted to such migrants. And this is very currently politically very sensitive issue. So what is this remaining in the Slovak Republic territory? It is governed by also the Act on Residence of Foreigners, and it is the case when the third country national staying in the territory without authorization. So the police department, according to such Act on Residence of Foreigners, shall issue a written confirmation about the possibility to remain in the Slovak Republic territory. So this is such confirmation should not be considered as a residence or authorized stay in the Slovak Republic territory. Such third country national is obliged to leave the Slovak Republic within 7 days of expiration of the reasons for which he or she could remain in the territory of the Slovak Republic. And what are such reasons? The first of all is the duration of the obstacles to administrative expulsion, and we have a couple of other reasons, but In current situation in Slovakia, we are dealing with higher numbers of the migrants that are continuing their way to another countries. So this written information to remain in Slovakia is considered as by politicians as a pull factor to migrants, because of course Slovakia Republic is migratory route to Schengen area, and of course in case that a migrant has such a confirmation to stay in the territory on the Slovak Republic, we have to deal with consequences which are in a return and readmission procedure. So nowadays, the Slovak government prepared the change of the Act on Residence of foreigners, where or based on such changes, the confirmation will be granted only in case of obstacles to administrative expulsion, and also the amendment of Act should be written should change that the termination, as I already mentioned, shall issue written information. So after the changes, it will be may issue the written confirmation, and the change will affect mainly the transit migrants. So we'll see what the future will bring to us, and also the final results of the elections, and how we'll change the current situation in Slovakia. So thank you very much, and I can now finish the sharing of the presentation. So thank you for the word.
Thank you very much. And now I have a question if Professor Dawid Szechnelek has solved his problem, maybe.
Can you hear me now?
Yes, we can. So
Excellent.
the floor is yours.
Sorry for this inconvenience and for the problem I have experienced, and I will share my presentation. I hope that you can see it. And well, dzień dobry. It is a pleasure to be here, and I think that I will skip all the formalities due to the fact that, you know, the limit of 10 minutes is kind of killing me. I'm usually speaking 100 minutes, so this is very restrictive, but I fully understand reasons. So the past decade has been characterized by two waves of migration in our geographical area. One of them started in 2015, when the number of refugees arriving in the European Union dramatically increased to 1 to 2 million refugees per year, with Italy and Greece being the most exposed countries. The second major wave of migration, as you all know, occurred last year as a result of Russia's invasion of Ukraine. And according to UN data from spring, there were over 8 million Ukrainian refugees on EU territory. In case of the first sudden wave of migration, the Czech Republic was only a transit country for some of the refugees, and the number of people who obtained a residence permit in the Czech Republic and remained here is absolutely negligible. In the case of the second Eastern wave, almost 500,000 people from Ukraine actively headed to the Czech Republic as a destination, albeit initially temporary. And it is apparent that in terms of numbers of people admitted and their willingness to stay here in the Czech Republic, the two migration waves differ substantially. The approach of our state was also very different, and at a first glance, rather surprisingly, in a different way than we would have expected. Since the second wave brought more people to our country, but the reaction was more lenient and way more supportive. But let's go back to the first migration wave. The 2015 migration crisis began to affect the Czech Republic in a real and immediate way only when the EU adopted two measures in order to relieve Italy and Greece by relocating migrants to other EU countries, Czech Republic being one of them. And this solution was extremely unpopular among all Visegrad countries, including the Czech Republic. And both these decisions of the European Union have been challenged by actions for annulment brought by Slovakia and Hungary, which to me is kind of amusing. It is an amusing constellation confirming the quote that enemy of my enemy is my friend, as it is not usual for these two countries to be on the same side of the barricade. But back to the topic, the pleas in law were several, both formal, such as defective legal basis or breach of formal requirements, and substantive. And none of them was accepted by the Court of Justice. Personally, I would consider, for example, proportionality of the measure to be a problem, but proportionality is generally a problem with EU legislation. It is a problem in the sense that together with subsidiarity is only examined formally. Surprisingly, the Czech Republic did not join the action, despite the fact the Czech Republic did not actually comply with both decisions. Only 12 applicants for international protection from Greece were relocated a year on the basis of both decisions. As of May 2016, the Czech Republic had no longer made any commitment to relocate. As a consequence, the Commission has taken the Czech Republic as well as Poland and Hungary to the Court of Justice for infringement of their obligations under the EU law. And the Czech Republic defended itself with both formal and substantive arguments. It argued inter alia that it did not have sufficient information about the persons concerned, about the migrants, so it could not assess whether they are a danger to national security or public order. Well, surprisingly, the Czech Republic has not raised a national identity protection as a reason to defend its position. I assume that the government had, quite correctly, I think, assessed the futility and appropriateness of asserting such a ground, yet currently, in my opinion, the ground was present. And the court quite understandably rejected all arguments against both decisions. And the reference to public order and the protection of national security was also rejected. And I believe that the mistake was that this argument was applied indiscriminately by the Czech Republic generally. And this called into question the act as such, but that was already the subject of another legal proceedings, that of annulment. So the result was that the Czech Republic and other states were convicted of breaching the EU law. And in summary, the whole situation is paradoxical. It started with the fact that although we have a valid piece of legislation, which is the Dublin III regulation, for purely factual reasons, many states couldn't comply with it. And the situation is then resolved by adopting an exceptional measure on a very general legal basis of Article 78 of the Treaty on Functioning of the European Union, which, by the way, has been used for the first time in history. And in my view, no one even anticipated when this provision was adopted what its consequences might be. After all, if you look at the commentary literature, there is not much to be learned from the commentaries to this article. And the solution that was subsequently adopted was problematic for many reasons. For example, because it did not address at all the questions of whether foreigners want to enter Czech Republic. And importantly, even more importantly, whether they are capable of being integrated here. And it also represented a major hit on state sovereignty, as it forced states to accept foreigners on their territory. On the other hand, it was a solution which was rather mechanical and thus quick, and that was needed. And what is even more paradoxical is that in a situation where both decisions are evaluated by the Czech Republic, the only thing that EU could do, given the temporary nature of both decisions, was to declare that the Czech Republic has violated them. So we breached the EU law, but that's it. It does not have any consequences on both other states, Greece, Italy, migrants, or the Czech government. But what does the whole situation say? And in my view, there are two things relevant to the law and one factual. And on the legal one, since this is what I consider important on my presentation. First, many experts have recently paid attention to the so-called national identity. And this is an EU concept, and as such is subject to an autonomous interpretation. And this concept is enshrined in Article 4 of the Treaty on European Union. And to put it very simply, this provision can be seen as a way to an exception to otherwise a general regime of EU law. And in addition to this institute, there is a parallel institute called constitutional identity. Constitutional identity is defined by national law, in particular, at least in case of the Czech Republic, by the case law of our constitutional court. And it does not necessarily coincide with the concept of national identity in EU law. But at the same time, we can encounter a third phenomenon, which is very similar. And this is the national identity as conceived by the common man, by ordinary people. It is what ordinary people perceive as basic values of the society and the state they lived in. And this concept may significantly differ from the legal concept of constitutional or national identity. And another thing is worth our attention. It may sound surprising, but when people talk about national identity, in case of Poland or Hungary, they often mention values as the church or the traditional marriage, traditional family. But for an ordinary Czech citizen, secularism, perhaps atheism, may be part of his or her national identity with some limited tolerance of Christianity. And this brings me to another difference between the two waves of migration. I would like to point out that the people perceptions of the incoming foreigners differed significantly. For the average Czech person, the typical representative of the first wave was a healthy young man, a Muslim, with an expensive mobile phone in his hand. A typical representative of the second wave was a mother with a child. Her faith was, relevant to ordinary people. As a result, the people were tolerant in case of Ukrainians, but absolutely against southern migrants. By opposing the EU legislation, what I have described in the first part of my presentation, our government was just fulfilling the ordinary people's wishes and defending the popular national identity as it is perceived by ordinary people, and which was understood as the basis on which we should get an exemption from the general EU law regime. What is important is that we have very different, there is a significant difference, at least in the Czech Republic, in what can be considered national identity from the perspective of EU law or Czech constitutional law, and what majority people understand as national identity. Well, and the reason I'm addressing is that it could be a risk for the future of European integration on the basis of EU law. And the second thing I want to point out in my post is the fact that the EU law, both primary and secondary, is full of Easter eggs. The Article 78, Section 3 being one of such example. That is to say that there are provisions that are extremely general and that allow the EU to legislate in areas where member states did not foresee it. And at the same time, it allows the EU to adopt solutions that are unwanted by a significant number of member states and majority of their citizens. And on the one hand, the situations allows for fast and efficient integration, which is good, for example, in the area of trade in goods. But on the other hand, it is very dangerous. And that is all the more true the more the thinking of elites of the European Union differs from the ideas of the general people. This creates tensions that can ultimately have a disintegrating effect. And this is not, I believe, in the interest of any of us. Well, and if I have a last minute, my last remark is factual. I used to perceive Czech nation as a nation which is rather xenophobic. And there are certain historical reasons which may explain such an attitude, but I believe that I was wrong. First, there is a very large Vietnamese community living in the Czech Republic, which is clearly different from the majority population, yet nobody minds. And secondly, with some exceptions, the Czech nation has been able to absorb and help many refugees from Ukraine, a country that many people looked down in the past. So I do not think that things are as bad with us as they might at first appear, but there is this problem with migrants from Muslim countries. So thank you, dziękuję for your attention, and thank you for the possibility of being here.
Thank you very much, Professor. And now we have still two speakers in that expert panel. Now I would like to ask Professor Gregor Małczyc to take the floor with the speech Division of Competencies and Responsibilities Shared between UA institutions, agencies, and national authorities of member states in the context of border management and immigration.
Yes, thank you for your words. Just let me share my presentation. Just a second. Wow. Yeah, actually, I can't see on my screen. Just a second.
You need to open your PPT, and then you will have this option to share just your PPT, not all the whole screen.
Yeah, but when I open this window, choose how to share your screen, there is only entire screen.
If you want, you can send this presentation to me. We can change, move now to Professor Nora Beresh. You will send me your presentation, and then we'll give you floor.
Okay.
Okay, so for now.
Okay, thank you.
For now, I would like to ask Professor Nora Beresh to take the floor. A lot of changes today, but it's good. With the speech, the principle of non-refoulement in case of law of the ACATHR.
Thank you so much. Can you hear me and see me?
Yes, we can.
In a proper way.
But your video is upside down. I don't know how it happened. But
upside down.
Upside down, yes.
My video is upside down. Actually, I had some computer glitches when trying to connect to this meeting, and I wasn't able to join with my laptop. So I'm using my iPad, and
okay, but my colleague is saying it might be some problem with my computer because all of the people in the chat are writing it's good. So just please take the floor.
Okay. Okay, maybe I should start. Thank you again for inviting me to this conference. It is an overwhelming joy to share my thoughts on the principle of non-refoulement in the case law of the European Court of Human Rights. And due to the 10 minutes limitation in time, I had better get to the point right now. Maybe can I Okay, perfect. I can make this work. Well, first of all, we should clarify what non-refoulement means. This principle can be described as as an imperative of solidarity. It has a customary form under international public law, and it gives essential protection under international refugee law, human rights law, and humanitarian law as well. In a nutshell, non-refoulement prohibits states from removing non-nationals from their territorial jurisdiction or even from their effective control to a country where there is a real risk of persecution or serious violations of human rights. Non-refoulement appeared for the first time in 1951 in the UN Convention relating the status of refugees under Article 33, paragraph 1. And still in 2023, it serves as a cornerstone of international refugee law. However, the scope of the prohibition of refoulement under refugee law is slightly different from its scope under human rights law. And what it meant in more than 70 years ago is quite different than today, as we can or we must associate of the interpretative environment of international courts and other monitoring bodies when we like to explore the meaning of this principle. While in accordance with refugee law, there exist exceptions from this principle and its personal scope only covers asylum seekers and recognized refugees. And in accordance and by contrast, human rights law, non-refoulement is absolute, no exceptions are needed and applies to anyone, including, of course, asylum seekers and refugees. As far as international human rights law is concerned, the explicit prohibition of refoulement is worded under the UN Convention Against Torture and other cruel, inhuman, and degrading treatment or punishment, as well as the UN International Convention for the Protection of all persons from enforced disappearance. As for regional human rights instruments, the principle is explicitly found in the Inter-American Convention on the Prevention for Torture, the American Convention on Human Rights, and the Charter of Fundamental Rights of the European Union. As for the European Convention on Human Rights, explicit wording of non-refoulement is missing. Nonetheless, the European Court of Human Rights has guided that this principle is an implicit guarantee flowing from the obligations to respect, protect, and fulfill human rights. As early as 1961, the European Commission of Human Rights already raised in Acts versus Belgium that the removal of foreign nationals might be contrary to Article 3 of the ECHR concerning the absolute prohibition of torture or inhuman or degrading treatment or punishment. Almost 30 years later, the ECHR officially confirmed the principle of non-refoulement in Zering versus the UK. In this landmark case, the ECHR found that the so-called death row phenomenon, I mean the long waiting for the execution, would have breached Article 3 of the ECHR, namely the prohibition of inhuman or degrading treatment, if the applicant who was charged with murder had been extradited to the US, where he would have faced capital punishment. 2 years later, in 1991, the ECHR adopted a more cautious stance in Vilvaraya and others versus the UK. In that case, 5 applicants were asylum seekers from Sri Lanka of Tamil ethnicity, whose requests were denied in the UK, and they had been returned to Sri Lanka. In that case, the ECHR rejected the applicants' allegations that a breach of Article 3 due to risk of ill treatment and a breach of Article 13 because of ineffective judicial remedy had been committed by the UK. In Vilvaraya, the ECHR based its reasoning on the fact that the applicants of Tamil ethnicity were not in a more adverse position than any other ethnicities in Sri Lanka. Nevertheless, in Hahal versus the UK, the court returned again to Zoring, prohibiting the deportation of a Sikh separatist to India because of the risk of violations of Article 3. In Hahal, the ECHR hold that the prohibition deriving from the non-refoulement is made in absolute terms, irrespective of the victim's conduct. In Salasik versus the Netherlands and in Sadi versus Italy, unlike in Vilvaraya, the court held that if the applicant is a member of a community that is the target of persecution, he or she only needs to prove his or her membership of the persecuted community or the mere fact of persecution. In 2011, the ECHR delivered 2 relevant judgments that worth mentioning too. In MSS versus Belgium and Greece, the facts concerned an Afghan asylum seeker who fled Kabul in 2008, entered the EU through Greece and traveled to Belgium, where he applied for asylum. According to the Dublin rules, Greece was had to be the responsible member state of the EU for the examination of his asylum application. Therefore, the Belgian authorities transferred him there, where he faced detention in unhealthy conditions before living on the streets without any material support given by the state. At issue in the judgment was the risk of violating the right to life, the prohibition of torture, namely inhuman or degrading treatment or punishment, and the right to an effective remedy. Eventually, in this judgment, the court found that degrading living conditions can be a trigger of the prohibition of refoulement. In Sufi and Ami versus the UK, the ECHR highlighted again the principle of non-refoulement when it established that the deportation of 2 applicants to Somalia would constitute a violation of Article 3 because of the humanitarian crisis and indiscriminate violence in the African country. And last but not least, in Ottoman versus the UK, a case concerning a recognized refugee in the UK who was to be deported in the interests of national security to Jordan, the UK government obtained assurances from Jordan that the applicant would not be subjected to ill treatment and would be tried fairly by the Jordanian authorities. Even though the efforts of the UK, the court found a violation of non-refoulement in connection with flagrant denial of the right to a fair trial. Well, as for concluding remarks, in my presentation, I have only tried to give a brief sneak peek of the ECTHR's case law related to non-refoulement. According to its jurisprudence, the court seems to be not that bold, unlike the Human Rights Committee, for example, as it was reluctant to enlarge the scope, the possible scope of non-refoulement beyond the prohibition of torture, inhuman or degrading treatment or punishment, the right to life, freedom from slavery and arbitrary detention, and the right to a fair trial. However, what is more important, the ECTHR recognized expressis verbis the absolute nature of non-refoulement. I'm afraid that my time is up, so this brings me to the end of my presentation. Thank you very much for your attention.
Thank you very much for your presentation and all the conclusions. And now, last but not least, of course, Professor Gregor Małczyc, please, the floor is yours.
Thank you. Just a second. Yes, hello everyone. I'd like first of all to thank the organizers of this conference for inviting me to participate with my presentation. And at the same time, I'd also like to point out that this is my first dissemination event. So I'm very pleased to be speaking to you my research from perspective, also highly complex topic, namely the division of competences and responsibility in the national authorities, member states on the other. As you know, the EU has a shared competence and shared responsibility for developing a European integrated border management system, thereby taking into account also the effective not only to the loss this is in compliance with the acts of EU border management and migration. Even more complicated, the EU integrated border management is carried out within a multi-level governance system of binding rules and different actors, thus raising concerns as to the exact allocation of competences and corresponding obligations and responsibilities conferred on or held by each of these actors. So in my presentation today, I'll be focusing mainly on the EU competence and responsibility in the view of in this area, leaving the obligations and responsibilities of the member states' border authorities within the framework of it, and also external action by the EU for an occasion. So I thought it would be useful to this subject into the following key topics. First, the main subject of inquiry and question. Second, the rules of primary law confer border management in the area of security and justice, as well as the European integrated border management. Third, the EU's objectives of the context of migration challenges and the nature and the exercise of the institutions and agencies' competence and responsibility in this particular field, and I'm with the limits on action by EU and its institutions and agencies in the area of border management and migration. To begin with, as part of the EU's comprehensive approach to migration, the European Commission in March this year came up with the first strategic policy document to provide a framework and guidance for the implementation of an effective European integrated border management system for the period 2023 to 2027. With ensuring effective control of the external lands. This communication is built around the vague concepts of shared responsibility and borders between the EU institutions and agencies, as well as national authorities of member states responsible for border management, and well-defined division of competence and work among them. There's the lack of clarity in legal terms as to the content of laws and the scope of mandate and responsibilities that each of these institutions and authorities is competent to exercise in the context of the development and migration. The confer of competence to EU migration issues does not result in member states losing their own competence and in this particularly sensitive domain from several legal complex questions. The core question that I search address is what the vision of competence responsibilities between the EU institutions and the member states' authorities on migration, inclusive management issues. There are, moreover, also some sub-questions that can help us answer these main research issues that can be regulated by the EU, any issues we have in some countries. How EU legal institutions that are directly applicable in and instruments that are directly applicable in the member states impact on the accountability of their border guards in the area of border control. Then also, what is the nature and complete content of the EU institutions and agencies' competence and responsibilities in this area and so on. So these obscurities may lead to unduly shifting, failing to enforce or overstepping by the institutions, agencies, and authorities involved of their legal powers or responsibility in the field of border management and migration. Article 5 of the Treaty on European Union sets out the principles that govern the relationship between the competence of the EU and its member states. The principle of conferral, which the legally is competence, is the EU may only act within the framework of the competences conferred agreed by the member states in accordance with the conditions laid down in the treaties, whereas competence is not conferred on the EU in the treaties to remain member states. Moreover, the EU may only exercise its competences to achieve the objectives located in the treaties. One of the objectives of the members assigned to the EU is the establishment of a common policy on external management. Article 3 of the Treaty on the European Union calls for appropriate measures with respect to external border control in order to offer the EU citizens an area of freedom, security, and justice without internal borders in which free movement of persons is ensured. The EU aims to establish some standards for controls at these external borders and place European integrated system for managing. According to the story 67 of the critical function of the European Union, the general visions on the title of the area of security and justice, each to develop policies and border control. 77 of century that the initial development policy with a view to ensure the absence of controlling persons. While they are nationality and crossing internal borders, when carrying objects on Earth and monitor the crossing of external borders, and the curriculum instruction of inter-distance for external borders. The external border management, the EU aims to develop and implement other integrated border management at national and EU level as one of the compensation measures for the free movement in the European Union. This European integrated border management is commonly done as a nation and cooperation among co-relevant authorities and agencies at EU and member states level involved in border management activities to ensure effective and coordinated border management that use the external borders, thus attaining the objective of open but well-managed secure borders. Next, national authorities responsible for the management of external costs are inspired the American border surveillance operations and any other border control tasks, as well as the European Border Guard Agency from share the responsibility to implement European integrated border management. But it's not mean they assume, of course, the roles. And while member states are the primary for the management of their sections of the external borders and are responsible for issuing intelligence, Frontex supports the application of the measure related to manage the external borders and return by providing signals, which is personnel, equipment, financial resources to member states in their management of external borders. However, Frontex is responsible and accountable for any activity for which it is solely responsible under the regulation of the state. In order to achieve its objectives concerning European integrated border management, the EU may act pursuant to Article 77 of the Treaty of the Function of the European Union in the areas such as common policy, visas, and other short-stay residence permits, which persons cross external borders are subject conditions under which nationals of third countries shall have the freedom to travel within the Union for a short period, any measure necessary for the gradual establishment of an integrated management system for external borders and the absence of any controls on persons, whatever their nationality and the internal borders. However, the distinction should be drawn between internal and external competencies of the institutions and agencies as to be a foreign share. The EU has shared not competence, but also operational competence and coordination. Externally, the Treaty of Lisbon confers on the EU space external borders to complete agreements with third countries. The functioning of the European Union may conclude agreements with third countries for their admission to their countries of origin or provenance of third country nationals who do not who no longer fulfill the conditions for entry a presence for the territory of the member state. Protocol number 23 on external relations of the United States with regard to the crossing of the borders and which is attached to the Lisbon Treaty specifies that provisions on the measures of the external borders included Article 77 of the Treaty of the European Union shall be without prejudice to the competence of member states to negotiate or conclude agreements with third countries as long as they respect Union law and other relevant international agreements. In addition, the possibility of states to enter into agreements with third countries concerning measures on the crossing of the external borders. Cooperation with non-EU countries on border management issues is carried through activities of the front agency. European Border and Coast Guard regulation broadened the agency's mandate on some areas, including cooperation with countries. So, according to this regulation, the agency may cooperate with the authorities of other countries, failing with these agencies, with third countries covers all areas of cooperation, including information exchange, risk analysis, joint operations, return, training, research and innovation. And it can be divided, roughly speaking, into three types of operation. First, operational cooperation and assistance and technical assistance through financing different projects in third countries, and third, return cooperation. The exercise of use competence in relation to border management and regulation does not affect the competence of the member states. The volumes of third countries admitting to maintenance of law and order and the part of internal security. So these are some of the list on the action by the institutions and agencies. Also, according to Article 72 of the Functioning of the European Union, these actual facts the of member states with regard to means of law and order regarding internal security. The EU's legislative competence, but rather its operational competence. The adoption of measures to implement the EU falls within the competence of member states. Yet, the EU's operational competence is accordingly limited to support and coordination of member state action. This translation of member state competence does not include all forms of control. The European Union has noticed that member states are required, in accordance with the principles to exercise in connection with the maintenance of public order and internal security, so as not to hinder the full effect of the region's conflicts in other areas. And then there's also the territorial bit. For the the scope of the EU's competence area border management immigration is limited by the exemption of Ireland and Denmark. It covers the whole area of freedom, security, and justice. Protocols number 21 and 22 to the Treaty of Lisbon, these two EU member states, Ireland and Denmark, are free to choose whether or not to participate in convention issues and immigration. However, these member states are not in that position when the EU actually third country nationals are adopted under our competence. Moreover, as the EU's competence in question with management and integration is shared competence, the establishment of enhanced cooperation may be considered. And in that case, acts related to legal immigration adopted under the enhanced cooperation will be binding only on those EU member states which are parties to the act in question, why other member states may choose to participate. And I'll stop there. Thank you for listening.
Thank you very much. I'm closing this presentation, and now I got the last minute information that at the end of the conference we'll have a special guest with an additional speech. It will be Professor Erika Vara-Diciema, who is supporting us today at the meeting as one of the people from a scientific committee. So for now, I propose to take break until 12 o'clock. So we'll see each other in 15 minutes.
Excuse me. Now is the break or?
Yes, now is the break, and
Okay,
you will
thank you.
presentation
Thank
until
you.
very end.
Okay, because I will be the last presentator.
Yes,
Thank
the
you
last
once more. Thank you for the possibility.
Agata, czy mnie słychać?
Słychać, tak? Wszystko w porządku?
Super, dziękuję. Okay, can you hear me?
Yes, yes, we can hear you.
Okay, so good morning, ladies and gentlemen. My name is Jan Abramowicz, and it's a great pleasure to welcome you to the second part of our conference. In this section, we have 6 speakers, and they are Mr. Bartlomiej Oręziak, PhD from Warsaw Institute of Justice, Agata Wróbel from Cardinal Stefan Wyszyński University in Warsaw, Tena Koniewicz from University of Osijek, Croatia, Tomasz Bojanowski from Cardinal Stefan Wyszyński University in Warsaw, Roland Lind from the Ferenc Madl Institute of Comparative Law in Hungary, and Julia Starybrat from Cardinal Stefan Wyszyński University of Warsaw, and Professor Erika Baradicheva. Now, I would like to invite you to listen to the presentation of our first speaker, Mr. Bartlomiej Oręziak. The topic of his presentation is the problem of EU principle of conferral immigration law.
So, ladies and gentlemen, warmly welcome you at this time as speaker at this international scientific conference. And apart from the fact that, as I said, I'm the member of the Central European Professors Network 2023, I'm also the assistant professor in the Institute of Justice in Warsaw, and here I'm the, also head of the Center for Strategic Analysis of the Institute of Justice. And today I would like to present the problem of EU principle of conferral in immigration law, but in fact, this problem, in my opinion, is not only in immigration or refugee law, but it exists in all EU law. The principle of conferral, as we all know, is the cornerstone of EU competences. This is because the source of the EU's competences are its competences transferred by sovereign states. The EU does not have the competences that are due to it because it is an international organization, and it only has the competences that it has been granted on the basis of autonomous decision of the states that are members of this international organization. This is expressed directly by primary law, according to Article 5, for example, of the Treaty of EU. The limits of EU competences are determined by the principle of conferral, according to which the EU acts only within the limits of competences granted to it by the EU member states in EU primary law to achieve the objective set out therein. Additionally, Article 5 of the Treaty of EU, also what is, in my opinion, crucial, underlines that any powers not conferred on the EU in EU primary law belong to EU member states. It seems that the wording, the sense of Article 5 of Treaty of European Union should leave no room for doubt. In some synergy, of course, with Article 5 of the Treaty of EU, remain Article 3, 4, and 6 Treaty of Functioning of European Union. So, ladies and gentlemen, in my opinion, the limits of EU competences are the same as the scope of competences transferred to the EU by EU member states in accordance with the principle of conferral. These scopes overlap as the EU has no competences, as I said, of its own. In other words, the sources of EU competences are the EU member states' sovereign competences. This means that if EU member states have transferred competences to the European Union, the European Union may exercise them, but only within the limits of the conferral and also the principle of subsidiarity and proportionality. If the EU goes beyond these limits, the consequences are tantamount to competence creep. For this reason, the provisions of the Treaty of Functioning of EU specifying the limits of the competences conferred on the EU in immigration or refugee law are of key importance in this scope. In addition, it seems that other interpretations of the law, in my opinion, is not justified by the content of EU primary law and the principles of public international law, and should be regarded as some kind of groundless. Here, the question arises, of course, about the entity which should be authorized to make abiding interpretations of the provisions of EU primary law, which directly determine the limits of the competences granted to the EU. And this question is essential not only, as I said, in migration and refugee law, but in fact in all legal order of a European Union. Ladies and gentlemen, it is some kind obvious that in the light of the version of EU primary law currently in force after the adoption of the Treaty of Lisbon, it is clear which entity is authorized to make decision in the field of principle of conferral. This entity is, of course, Court of Justice of European Union. However, the purpose of this presentation and my research in the group in our international group in the Central European Professors Network is not to, the purpose of this is not to indicate which entity is now legitimized for the perspective, from the perspective of the EU legal framework, but which entity in fact should be legitimized in order to increase the transparency of functioning of the European Union, counteract the phenomenon of competence creep, and prevent the blurring of the EU's status as an international organization. So at this point, it is necessary to consider, in my opinion, which solution best meets the objectives set in this way, justified by concern on the one hand for the sovereignty of the EU member states, and on the other hand for the compliance of the scope and form of European Union activities, which with the principle of conferral, also with the principle of proportionality and the principle of subsidiarity, that is the limits and use of EU competences, which have their own and determined by the actual will of the EU member states image in EU primary law. Ladies and gentlemen, the solution which consists in giving the decision-making field on the EU or to the EU institutions or one of them in the interpretation of principle of conferral, it should be stated that it is currently the current and functioning standard in the European Union. Of course, in the light of Article 19 Treaty of EU, this is the Court of Justice of the European, that is an EU institution whose task is to respect the law in the interpretation and application of EU primary law. It should be emphasized, however, that such a solution, in my opinion, is not conducive to objectively controlling European Union activity in the triad of principles set out in Article 5 Treaty of European Union, which have their own and fundamental specificity. We are also taking here about the fullest possible implementation of such objectives as increasing the transparency of the EU's functioning, counteracting the phenomenon of competence creep, and preventing the blurring of the EU's status as an international organization. It should even be noted that, in my opinion, unfortunately, the adoption of the currently assessed solutions in the European Union actually leads to the opposite effects. It seems that the reason for this state of affairs is some kind of nature character. If the EU is to decide on its own about the scope and form of exercising its competences through a creative, because it is based on theological interpretation of the principle of conference, this leads to the lack of, in some part, on some level, the lack of objectivity. After all, as we all know, objectivity is lost in the first place when one is a judge in one's own case, nemo iudex in causa sua. Such a situation occurs in the analyzed case, in my opinion, because, as already mentioned, the principle of Article 5 Treaty of the EU have their own and fundamental specificity, that is that these norms are like meta-norms deciding about the validity of the other norms in the EU legal order. it seems that a very important purpose of the principle of conferral is to act as a watchdog, so that the EU acts in accordance with the actual will of European Union member states that expressed it by being bound by the provision of EU primary law. Therefore, if we assume that the principle of Article 5 of the Treaty of EU is the watchdog overseeing the European Union and continuing this example, this watchdog cannot be employed by the EU, including paying him and deciding on his responsibilities. In such a situation, the function of a watchdog misses the point. In my opinion, it is illusory. And ladies and gentlemen, the entire issue, in fact, concerns the coding of the image of the actual will of the EU member states from the moment of binding the current version of the provisions of the EU primary law. It seems that this leads to the conclusion that in my opinion, maybe it is not the EU institutions, but maybe the EU member states should express their opinion on the actual scope of their will from the moment of binding the current version of the EU primary law. Why? Because they created the European Union. The sources of the European Union competences are the EU member states' sovereign powers. EU member states defined the content of the principle from Article 5 of the Treaty of EU, and these European Union member states, in fact, have the most complete information regarding the image of their will. In such a situation, EU member states will not be a judge in their own cases, in my opinion, because there is no dispute here, but sovereign decision-making on the scope and form of exercising state powers. In my opinion, this is the essence of sovereignty. In the context of the letter, it is worth mentioning that the EU as an international organization does not have the attribute of sovereignty, and therefore in the same situation it will be the judge in its own case. Therefore, leaving the decision-making field in the interpretation of the principle of conferral to the EU member states seems to be justified at currently level of my research, but I'm not sure that it will be the ending conclusion. Maybe yes, maybe not. But now I'm more similar with this option that the EU member states decision makers seems to be sufficiently justified not only in the area of course, border control, asylum and immigration policies, but also more broadly within the entire EU legal order, but only with the scope of the principle of conferral, principle of proportionality and subsidiarity, as here, as a rule, the appropriate entity is the member states as a decision maker. Nevertheless, in my opinion, this conclusions that does not apply to other provisions of EU primary law as other than the principles expressed in Article 5 of Treaty of European Union, as here, as a rule, in my opinion, it is true that it is appropriate for the Court of Justice of the European Union to interpret it. Why? Because these provisions do not have the status of meta-norms, but rather have a standard character. And with this accent, I would like to end my speech as ending conclusions, signaling the current state of my research in a research group in a Professors Network 2023, in a research group Migration Challenges, Legal Responses, headed by Professor Marcin Wielc. And thank you very much for your attention. Thank you very much.
Thank you very much for this insightful introduction to the topic. And the title of the next presentation is Illegal Migration and Human Trafficking in the European Union, Legal and Social Challenges. And it will be delivered by Ms. Agata Wróbel.
Thank you very much. I shared my presentation. I believe that it is visible. So I would like to tell you something about also Polish background of legal aspects of that phenomena. Because illegal migration and human trafficking are two related issues, of course, that pose serious challenges for the European Union. And the line between legal and illegal migration can sometimes be thin. For example, a person who illegally crosses a country border and then applies for international protection in the presence of border guards can legally remain in the country as long as the asylum procedure is ongoing. International law stipulates that a person fleeing persecution should be assisted even if they uses illegal migration channels. So because of the blurry distinction between legality and illegality, it is suggested to use the term migrants with irregular status instead of irregular migrants, because no person is illegal. Only his or her acts their conduct may break the law this way. So therefore, speaking of illegal migration is still correct. And illegal migration often takes place with the help of smugglers and even human traffickers. A smuggler is someone who helps migrants reach their designated country illegally or by outwitting legal procedures. Smugglers arrange illegal border crossing, for example, in a truck, forge and sell passports, and issue tourists invitations to people whose goal is not just to, let's say, enjoy beautiful sights in the country, but to stay there illegally. Extensive networks of smuggling include many people for various tasks and operate internationally. In many cases, these networks operate for profit, earning serious sums of money for their services and far exceeding the cost crossing the border legally. In the case of human trafficking, the person organizing the smuggling on behalf of the smuggler this network is much more likely to exploit migrants. So a smuggler acting on his own and mainly interested in getting such a person across the border and receiving money from him. Human trafficking involves the person continuing to be exploited after reaching the destination country, such as being forced to work illegally as a prostitute in a workshop, etc., to cover those costs of smuggling. Trafficking victims not always migrate, of course, of their own free will, but are kidnapped also or transported to the designated country under compulsion. And the migrants with irregular status most often cross the border completely legally, but remain on the spot after the right to legal residence has expired. So, for example, a person arrives in the country with a work permit, but after it expires, for some reason doesn't receive an extension because he didn't apply for it or the rules of migrant labor have changed. And from the moment the document expires, such a person's stay in the country is illegal. Illegal migration is hard to prevent, but such risk can be mitigated, for example, by improving external border controls or for now, border services are increasingly using technologies like thermal imaging cameras, or drones that transmit information to a monitoring center about suspicious vehicles appearing in the border zone, even from a long distance. Nextly, people hidden in the cars can be found using heart rate monitors. And in some places, border walls are also being built for this purpose, and still documents control technologies are constantly improving. And the main reason for the existence of human trafficking include such circumstances like poverty, unemployment, low levels of education, and insufficient access to sources of assistance in so-called countries of origin, so mainly from Central Eastern Europe and countries of Africa and Far East. As well as the possibility of acquiring cheap, undocumented workers by employers from highly developed so-called target countries, so countries of Western Europe and the USA. In addition, human trafficking is linked to human smuggling. So the difference between these phenomena is that the first case, the victim don't know or don't realize the situation in which they have found themselves. They are often convinced that they are going abroad and they will be engaged, for example, in lucrative childcare or something like seasonal field work. And going to Polish legislation, Polish legislation is concerned, the concept of human trafficking has been included in the form of a three-element definition, which consists of firstly the way the perpetrators act, secondly the means and methods they use, and thirdly the purpose of exploitation. And according to Article 115, paragraph 22 of Criminal Code, human trafficking is the recruitment, transportation, delivery, transfer, storage, or reception of a person using violence, abduction, deception, misrepresentation, abuse of relationship, or giving or accepting a personal benefit. And thirdly, for the purpose of exploiting him, even with his consent. It's important, in particular in prostitution, pornography, or other forms of sexual exploitation, forced labor or services, begging, slavery, or other form of exploitation degrading human dignity, or for the purpose of obtaining cells, tissues, organs in violation of the law. Additionally, if the perpetrator's behavior involves a minor, it constitutes trafficking in person, even if the methods of means listed in paragraph 1 to 6 were not used. So, however, accepting the need to provide special protection to minor victims, the legislator limited the legal qualification of the perpetrator's acts only to the purpose of his action. Thus, in the case of minor victims, the second element of the definition regarding methods and means doesn't have to be disclosed for an act to be classified as a trafficking in person. And in Poland, according to Article 189 with letter A of the Criminal Code, whoever commits trafficking in person shall be punished by imprisonment for a term of not less than 3 years. But due to the high degree of social harmfulness, the legislator also introduced in the second paragraph the punishment of the stage form of preparation to commit the crime of human trafficking. Perpetration is a misdemeanor, so punishable by imprisonment from 3 months to 5 years. Yes, to 5 years. And we have also other crimes regulated by criminal code that are often related to the human trafficking procedure. It includes deprivation of liberty or forced behavior, then forced prostitution, pimping, facilitation, prostitution. All of these acts need to be protected by the law because it's commonly connecting with each other. And to sum up my presentation in some way, illegal migration and human trafficking present significant challenges for the European Union. And the distinction between legal and illegal migration can be complex with international law, emphasizing assistance to those fleeing persecution regardless of their migration route. And in Poland, human trafficking is legally defined based on the perpetrator's actions, means used, and the purpose of exploitation. Penalties for human trafficking range from imprisonment for a minimum of 3 years. Preparation for human trafficking is also punishable, which I said is for me very vulnerable. And other related crimes include deprivation of liberty, forced behavior, forced prostitution, facilitating prostitution, and each of them has its respective penalties. These legal measures aim to combat human trafficking and related offenses, reflecting the seriousness of these crimes and pointing the need to protect vulnerable individuals. That's all for me. Thank you very much for your kind attention.
We appreciate your fascinating presentation, and now it's time for Tena Koniewicz presentation on freedom of movement for workers within the EU, Utopia for Central and Eastern Europe workers.
Hello everyone, I'm just trying to share my presentation. I'm not sure how to share only the PPT. Am I sharing it now? Can you hear me?
Yes, we can hear you, and you have successfully showed us just your presentation. However, you are sharing the whole screen. We can see it now.
Is now okay? Can you please just confirm that you can see the PPT?
Yes, we can see your PPT, and yes.
Okay. Okay. Hello everyone, once again. I'm a teaching assistant at the Chair of Labor and Social Security Law Sciences at the Faculty of Law Osijek in Croatia. However, I'm also a PhD student of the University of Miskolc in Hungary, and I'm an intern at the Central European Academy in Budapest. And since I'm dealing with the European labor, I'm not going to deal with the migrations of the third countries nationals, but I'm actually going to focus on the inter-European Union migration, which means that I'm going to actually talk about the very controversial topic of the discrimination of the CA countries' workers in the Western countries. First, I'm actually going to talk about the principle of the free movement of workers, which is actually the principle that gave the opportunity to the workers of the European Union to move to the other country, to work there, and to be treated equally as the nationals of that member state. However, the focal point of my research is actually the Article 45 of the Treaty of the Functioning of the European Union, which prohibits the discrimination based on nationality in the scope of employment, remuneration, and other employment conditions. And the main problem is that the European Union by itself actually violated this article, but while the Central and Eastern European countries were acceding to the European Union, and I'm going to explain it why. But the equal treatment of workers in other in other member states is actually regulated not only by the primary legislation but also by the EU secondary legislation. But I'm not going to focus on that, and I'm going to actually explain what happened with the change in policy of the European Union towards the workers from the Central and Eastern European Union, part of the European Union, when they started to accede to the European Union. So there was actually a fear of Western countries when they even started to actually discuss on the freedom of movement of workers, that the potential of movement or migration of workers could potentially cause a serious disturbances of the EU labor market. And those fears were actually existent already when Greece, Spain, and Portugal actually entered into the European Union. But when Central and Eastern European countries actually started to enter into the European Union, the whole fear actually became even worse, because Western European countries actually thought that Central and Eastern European workers are going to totally damage the European labor market, And that's why they actually included the transitional arrangement. So probably you're all from the Central and Eastern European countries, and some of you maybe even remember that when your country was acceding to the European Union, workers from Central and Eastern European part were actually restricted from moving to the other country because of the transitional arrangement. So already in 2004, we had 10 countries that acceded to the European Union. And I actually emphasize the Cyprus and Malta because when we are talking about the transitional arrangements, we are talking about EU 8 countries, even though that actually 10 countries entered into the European Union in the same time. But Cyprus and Malta were actually excluded from the transitional arrangements, which meant that the citizens from the Cyprus and Malta could work in other EU countries without any restrictions. But Central and Eastern European workers couldn't because they were actually submitted to the restrictions by the transitional arrangement. That also happened in 2007 when Bulgaria and Romania entered the EU, and now actually at the last time it actually happened also with Croatia in 2013. So what are actually the transitional arrangements? It is actually the restriction of the movement of workers within the European Union for the new member states, which can actually last up to 7 years. For the first 2 years, the old member state that actually decides to implement the transitional arrangement can actually use the bilateral agreement to restrict the workers to enter to their territory. Then after those 2 years, they have to actually report to the council if they want to exceed for additional 3 years. And after those 5 years, if they want to exceed it for additional 2 years, they actually have to argue if the actually migration to their country would cause serious disturbances to their labor market. So this is actually the whole formula of the transitional arrangement, and almost all the member states applied transitional arrangements, excluding United Kingdom, Ireland, and Sweden. So what actually happened with the transitional arrangement? As I already mentioned, even with Greece, Spain, and Portugal, the transitional arrangements were applied. However, many scholars argue that it's not even comparable to the Central and Eastern European workers because the amount of people that entered by the CEA countries to the European Union is not even comparable with those countries because the amount is much higher. And also their financial situation when Greece, Spain, and Portugal were entering into the EU wasn't even comparable with the financial situation of the Central and Eastern European workers. Also, when we talk about Malta and Cyprus, they were excluded from the transitional arrangements, and I found a lot of documents from the European Commission where they were actually explaining why they excluded Malta and Cyprus. There were no concrete answers to that question. Why did they exclude them? Even in one document, they mentioned that they excluded Malta and Cyprus because they are islandic countries, which is totally nonsense. And actually, the main reason behind it is the financial situation of the Malta and Cyprus when they were entering into the European Union. But what is the final impact of the transitional arrangements? Those are the dual-tier EU citizenship. So when Central and Eastern European countries entered into the European Union, the main focal point and the main purpose of it was to break the border between the West and the East, because as we all know, the Iron Curtain didn't only actually divided the West and the East physically, but also ideologically. So all those post-communist countries found the entrance of into the European Union as a new opportunity to get new employment, better employment conditions, better employment opportunities. But what actually happened? European Union actually discriminated the Central and Eastern European workers and introduced the transitional arrangements which actually put the Central and Eastern European workers in the status of second-class citizens. When we talk about that stereotype and that discrimination of Central and Eastern European workers, there is actually a very commonly used stereotype of Polish plumber in the Western countries, which is actually the joke for the cheap labor force from the Central and Eastern European part of the European Union. Actually, I talked to the Belgian professor in Geneva on the conference, and he actually said that that stereotype of Polish plumber or that joke is still used in a common language. And also what happened with the transitional arrangements, so they actually excluded the workers from moving abroad to other EU member states, but they haven't excluded the self-employment system, which meant that a lot of Central and Eastern European workers suddenly became self-employed people in the Western countries, which is totally nonsense. If they actually wanted to exclude all of the workers, they should exclude all of them or none of them. And the general fact of the enlargement and the introduction of the transitional arrangement was actually the continuation of the cultural racism toward the Central and Eastern European workers. So instead of equalizing the European Union citizens in the whole European Union, they actually caused that Central and Eastern European workers are still seen as easily manipulative and cheap labor force that actually fill in the gaps in the workplaces that are not desirable for the domestic workers. Also, it actually means that the situation from the entrance into the European Union until nowadays is not changed. And I actually did the huge empirical research on 200 Croatian citizens living in Germany in order to actually see if that situation is still ongoing, if they still feel discriminated, if they are still working from the salaries that are lower than for the domestic workers. And the results were actually very devastating because they showed that a lot of Croatian workers are still discriminated because they belong to the Central and Eastern Europe, and because they are seen as actually that second-class citizens. I'm not going to deal with that empirical research, but if you are actually interested in it, you can read my paper, which is going to be published in the Ljubljana Law Review very soon. I will actually close my presentation with it because I just don't want to exceed my time. If you have any questions, you can always contact me. Thank you.
Thank you very much for shedding light on the topic of freedom of movement for workers within the EU. Next, I would like to pass the floor to Mr. Tomasz Bojanowski, who will elaborate on the role of the border guard in fighting and preventing migration crime.
Thank you, Jan. Good morning, ladies and gentlemen. My name is Tomasz Bojanowski, and I'm a PhD student at the Doctoral School of the Cardinal Stefan Wyszyński in Warsaw, at the Department of the Criminal Procedure at the Faculty of Law and Administration. In my presentation, I will try to discuss issues related to the role of the border guard in the counteracting and preventing crime. This issue acquires particular importance in the context of migration problems in Europe, including the Polish-Belarusian border crisis. The paper will discuss the role of the position of the border guard in the system of the legal protection authorities of the Republic of Poland. Then I will analyze the statutory powers of this body, for example, administrative order, investigation, and operational exploratory activities in the context of the fulfillment statutory task. In final part, I will summarize the findings and propose the lege ferenda solution. So, at the outset, it should be known that the protection of the state border on the land and the sea and the control of the border traffic is undoubtedly one of the most important tasks aimed at ensuring national security. It's worth noting that in the terms of the function, the border guard replaced the border protection forces in 1991. According to the provision of the Border Guard Act, the Border Guard is uniform and armed formation designed to state border protection, border traffic control, and the preventing and counteracting illegal migration. Around these planes were built further tasks of this uniform formation. Consequently, it plays a key role in preventing and counteracting migration crimes. The discussed planes are the resultant for defining the detailed task of the Border Guard. The tasks of the Border Guard are carried out with the varying intensity according to the current threat assessments, which the formation develops within the framework of uniform project with special services. The catalog of tasks of the Border Guard is set out in the principle exhaustively in Article 1, Paragraph 2 of the Border Guard Act. The legislator did not use the formula in particular or the similar one, suggesting that the commanded provision is only exemplary. It's not an enumerative list of the tasks of this formation. The tasks of the Border Guard also include the performance of tasks set out in the other laws. In this way, the legislator left a certain margin of the freedom should the need arise in the future, for example, as a result of the current circumstances in the country, to assign the Border Guard some new tasks which were not directly specified in the provision of a law, but which would fall within the profile and the specificity of the activities of the service. This may be necessary, especially in the light of the rule of the according to which public authorities and therefore uniform services as well may only perform tasks and the competences precisely define the legal regulation and the implicit ones, constituting an over-interpretation of the law in force. It should be also emphasized that also at the present time, the powers of the Border Guard are also defined in other legal acts statutory rank, inter alia State Border Protection Act, Alliance Act, the Act of the Aviation Law, and the Act granting protection of foreigners within the territory of the Republic of Poland, and the Act protection of shipping and the seaport. The Border Guard also remains involved in the undertaking within the international bodies, one of the main tasks of which is develop the principles of the cooperation in the field of the safe exchange of the information, prevention, protection, prosecution, and the response to terrorism, improvement of intelligence gathering, processing, and analysis. The aim of the cooperation is to develop joint procedures in the fight against terrorism, both with national entities as well as those of international importance. In this respect, the Border Guard cooperates with the Europol, Interpol, and Frontex. It should be noted that the Border Guard is, apart from the special services, the only formation in the Polish legal system for which the legislator provided the provision of the right and obligation to undertake action in the field of the counteracting terrorism. According to the wording of the prevention of the provision, the task of the Border Guard include cooperation with the other authorities and services identifying and counteracting threats of terrorism. Provision of Article 9 of the Border Act define the type of the scope of activities undertaken by the Border Guard. Importantly, they may be undertaken only in order to recognize, prevent, and detect specific crimes and the offenses which remain with the material competence of the Border Guard. Three types of activities should be indicated: administrative order activities, investigate, and operational and exploratory activities. Operational and exploratory activities of the Border Guard, as in the case of the other services, are characterized as a separate system of confidential and secret activities conducted outside the criminal process, but usually serving the current or future purpose of this process and performed for the purpose of preventing and counteracting crime and other legally defined negative social phenomena. They have a subsidiary role to that of the criminal process preceding the pretrial proceedings by providing the justification for intending a pretrial proceedings. Operational and exploratory activities are not regulated in the separate act, but in act regulating the activities. For example, in Police Acts, International Security Agency Act, or precisely the Border Guard Act. The border guard also plays an important role in the criminal proceedings through its powers to carry out investigative activities. Pursuant to Article 311 of the Code of Criminal Procedure, the investigation is conducted by the public prosecutor, who may entrust the police with the conduct. According to Article 312.1 of CCP, the powers of the police are also vested in the bodies of the border guard. However, pursuant to Article 325A, paragraph 1 of the CCP, an investigation may be also conducted by the border guard. So the border guard also performs activities upon the order of a court, prosecutor, and the other competent state authorities in the extent that an obligation has been specified in a separate provision. Number of activities are performed on the order to the court and public prosecutor are specified in the Code of the Criminal Procedure. The border guard, following the example of the services of a law enforcement nature, is entitled administrative order activities, which supplement to the range of the activities. Their purpose is to legally and formally enable the performed task in the field of the detecting criminal and the prosecuting the perpetrators. In summary, the border guard plays an important role in the system of the legal protection authorities of the Republic of Poland. The recent events related to the migration crisis on the Polish-Belarusian border confirm that the bodies that warrants the broadly understood security of the Republic of Poland. It should be stated that the catalog of the powers of the border guard has been defined correctly. The service has operational and investigate powers in order to prevent and counteract migration crimes and the other crimes that fell within their competence. The specific nature of migration crime requires the functioning of the body such as the border guard. Moreover, it must be equipped with the adequate powers to fulfill its statutory duties. Two aspects that should be improved should be pointed out. Firstly, the organizational aspect. The service should have the best possible technical tools to detect crime and protect the border. Of course, attention should be paid to the aspect of interference in the protection of human rights. Secondly, the mechanism of the cooperation should be developed between the border and the other services. In national aspect, it should be, for example, the police, the International Security Agency, Internal Affairs Agency, and certain Anti-Corruption Bureau, and of course the Polish Army. Only by coordinating the activities of the individual services and appropriate mechanisms will it be possible to effectively prevent and counteract crime. For this purpose, an international document or strategy should be created, which would be regulate the cooperation in this question. The possibility provided by the legislation to assign a further task of the border guard in the other acts, which remain within its competence, should be evaluated positively. Therefore, the current social reality should be monitored in order to adequately prevent illegal migration. Thank you very much, and see you again in the future.
Yes, a big thank you to Mr. Tomasz Bojanowski for his comprehensive presentation. And now Mr. Roland Lind is going to present us the topic of a less discussed issue of the religious consequences of migration, the phenomenon of deviant religious groups, experience and possible treatment regarding cultic activity.
Okay, so good afternoon, ladies and gentlemen. Do you see the presentation right now?
Yes, we see.
Okay, thank you very much. So first of all, I have to express my gratitude towards the organizers for giving me the opportunity and the honor to participate in this conference by introducing my research regarding the possible disadvantages of mass migration in connection with religious deviance. Let me introduce myself. My name is Roland Lind, a researcher of Ferenc Madol Institute of Comparative Law in Hungary, and also a PhD student from September of the University of Miskolc, Deák Ferenc Doctoral School. I assume that when I mention religious deviance, the term terrorism came into everyone's mind, but this time I brought another more hidden problem, the phenomenon of cultic activity. After the fall of the Berlin Wall, in other words, after the end of the bipolar world order and the Soviet hegemony in the area, new ideologies spread through Eastern Europe. Besides this fact, those who were offended by the wild capitalism could feel their life hopeless and pointless, since many people have felt the loss of that old sense of social security provided by the socialist era. In these people, the will of belonging to somewhere increased, and that was a good starting point for cultic movement. But why am I referring to social process that took place more than 30 years ago? The reason is that from a certain point of view, a very similar process is happening right in front of our eyes. The two occasions compared here were provoked by different historical causes, as we all know. Regime change was in connection with the fall of the Soviet Union. Meanwhile, mass migration has many causes depending on the country of origin we examine. However, it is crucial to highlight that the main problem of today's mass migration is the huge amount of economical migrants whose intention is to settle down in Europe, hoping a better quality of life. Despite this fact, the prevailing political view in the European Union treats all the people who arrive as they were refugees. This, let's say, collision of notions causes huge tension between the member states, but that is a question for another day. Nowadays, the huge masses arriving at the same moment of time makes unable for the national authorities to check everyone's identity properly. This way, we are not able to filter out all the potentially dangerous elements. Therefore, it is not a necessary but a possible outcome of today's process that cases of religious deviance may appear and newly formed religious groups will become radicalized. But what kind of threat are we facing exactly? Before the examination of legal challenges, we had to create an acceptable definition that covers all cultic movements. When referring to these groups, to be politically correct, henceforward I intend to use the term destructive religious movement, or the abbreviation DRM. As a starting point, we use the results of sociology and religious studies. During this process, we encountered the term heresy that showed similarities. Heresy and cultism were a lot alike by sharing as a main characteristic the misinterpretation of the doctrines of a historical church. The main difference is that cults also have the so-called contra-attitude that makes them harmful to society. This leads us to a potential legal definition. A destructive religious movement is such a religious movement that, based on the modified doctrines of a major world religion, exists and works separated from the historical churches and is harmful to society. Apparently, making difference is not that simple in practice. Some groups were evaluated differently throughout the centuries. On this slide, I came up with 3 possible aspects that may help with the categorization of DRMs, which can be relevant in the legal evaluation. After having analyzed real-life examples, we were able to identify 2 typical patterns and thus distinguish 2 major categories. The first one, where the leader or leaders is mentally sane, the purpose tends to be the financial exploitation of the followers. Examples belonging to this category, although economic crimes have been committed in some cases, do not realize violent acts and the chance of radicalization is very low. The other category, where the leader is mentally ill person and both the members and outsiders' physical well-being is endangered, demands a more effective action from the authorities. These groups are usually smaller, harder to notice, and become violent suddenly. In our opinion, because of mass migration, new DRMs belonging to this second category might appear in the affected countries. But what is so special about such movements, and why do we need a new approach against them? In order to highlight some major issues, I brought as a famous historical example the story of the so-called Manson family. The founder of the movement, Charles Manson, created a particular folklore around himself using the Beatles' White Album. He interpreted the song Helter Skelter as if it was the description of the Armageddon, which can only be survived by joining his family. During his rituals, he usually made his followers consume LSD and other drugs, and also forced underage girls to please sexually strangers for accommodation. However, the authorities did not detect these activities. The real landmark was the event of 1969 that shocked the whole world. The members of the family, following the command of Manson, brutally murdered the famous actress Sharon Tate and her friends in her Los Angeles residence. A few days later, another massacre was realized by the same perpetrators, in which Manson gave more accurate instructions to proclaim his message properly. Both incidents shared common features: torture, various stabs on the bodies, messages written with the victim's blood. The most unsettling part of the story is that Manson's disciples were ready to testify during the trial with the intention of clearing the person's name who made them criminals. Concerning the case, we have identified 4 major problems. Firstly, the illegal activity of the group remained undetected for too long. The earlier detection may have saved the lives of the victims. Secondly, in such situations, it is almost impossible to find sufficient evidence to make an accusation. These groups usually live in isolated places, and moreover, the loyalty of the members to each other and the leader is hardly breakable. Thirdly, the main object of such proceedings is the conviction of the leader. Unfortunately, the members would do everything to clear their shepherd's name, therefore they would probably make a false testimony at the court. Finally, it can never be evident if the leader is in fact mentally ill and thus shall not be found guilty due to insanity, or is just a great manipulator. Subsequently, I observed whether Hungarian substantive criminal law is suitable for handling this phenomenon. The criminal offense shown on the slide is called violation of the freedom of conscience and religion. It can be seen that it punishes the violent restriction of one's conscience and the violent prevention of exercising one's belief. In other words, the relevant offense does not cover the behavior of manipulating someone by religious means to do something against his or her own interest. Furthermore, we have to emphasize that according to the Hungarian Public Prosecutor's Office official statistics, there have not been a single reported case. This data refers to the fact that this offense belongs to the area of the so-called symbolic criminal law. Through a deeper analysis, we have identified 3 significant issues why the Hungarian legal system in its current state cannot handle cultic activity properly. Firstly, the prohibition of religious manipulation does not appear explicitly. It can only be evaluated through rules on instigation, potentially. Secondly, there is no legal basis to sanction a DRM as a legal person when its leader realizes religious manipulation. And lastly, there is a low chance of detection before the radicalization takes place. Therefore, what are the possible solutions for these problems? Regarding detection in time and evidence gathering, certain procedural instruments may prove to be useful. Because of the specialties of the topic, an independent investigation body or a special operational department as part of the general investigative authority would be necessary. Moreover, with a view to gathering proper evidence against the leader, we shall not rely on the testimonies of the disciples. That is why the use of undercover investigators is indispensable. In respect of substantive criminal law, the already mentioned religious manipulation should be criminalized as a sui generis instigator-like criminal offense. By these means, DRM leaders could be sanctioned as offenders of a serious crime and not only as instigators of crimes committed by their disciples. Finally, when a leader of a registered religious association commits religious manipulation, measures must be taken to prohibit the functioning of the association itself. That is why it is desirable to create a legal obligation of cessation in such cases. And that was what I wanted to introduce concerning the topic of mass migration and possible religious consequences in a nutshell. So thank you for your kind attention.
Thank you very much for your presentation. Now I would like to pass the floor to Ms. Julia Starybrat, and the topic of her presentation is the crime of illegal border crossing, the perspective of Polish criminal law.
It's my great pleasure to present to you the perspective of Polish criminal law in the context of the crime of illegal border crossing. The topic takes on particular importance in the face of global migration and the challenges of controlling the movement of people across borders. The border guard, the main force responsible for the surveillance and protection of Poland's borders. Its stakes include controlling border traffic, combating border crime, patrolling border areas, and cooperating with other services in border security activities, such as the police and military. The rules for the entry, stay, and work of foreigners in Poland are regulated by the Foreigners Act, while the rules for legal crossing of state border are regulated by State Border Protection Act. Not forgetting international agreements which Poland is party of or European Union regulations. The history of Polish state border is complex and involves many historical events and territorial changes. Today, I will try to comprehensively discuss the offense under Article 264 of Criminal Code in both theoretical and practical terms. This is an important issue as foreigners attempting to enter to European Union countries illegally choose Poland as their destination or transit country. The object of protection of the indicated provision is to secure the state from being crossed in uncontrolled or organized way, and indirectly to also guarantee state security. However, let's start with the correct interpretation of the moment at which the state border is crossed. According to the July 26, 2001 Supreme Court judgment, it's to completion by an officer of the Polish border guard of an activity consisting of checking the validity and authenticity of documents authorizing the crossing of the Polish state border, and at the same time establishing the identity of the person holding these documents. When the border guard officers refrain from checking documents by giving a sign by voice or gesture, the officers signal the possibility to cross the border without checking documents and the identity of people crossing. In such a case, crossing the border will be crossing the border line. In all situations, the offense is common in nature and the act will always be committed by action. Section 2 defines the offense of illegal crossing of the border of the Republic of Poland in situation where the border is crossed in violation of the law, i.e. without the required documents and approvals. The elements of the offense are increased when the person uses violence, threat, deception, or acts in cooperation with other persons. This means that persons acting together to illegally cross the border can also be punished under the section. The punishment for the offense is a prison sentence of up to 3 years according to the Criminal Code. However, what about the qualified type, where third people are involved and are responsible for the offense under Section 3, Article 264, which is organizing the passage of other person in the country of their choice, punishable by imprisonment of between 6 months to 8 years. The regulation is addressed to persons responsible for planning, coordinating, or otherwise facilitating the illegal border crossing of a group of persons. The essence is the preparation stage when the offender takes steps to create the conditions for illegal border crossing, i.e. entering into an agreement with another person or persons in order to commit the offense, obtaining or adopting means, gathering information of drawing up a plan of action. This includes organizing transport by various means or planning a route to avoid border checkpoints. In all cases, the offenses are lacking in consequences are committed upon completion of the act itself. Conviction under the formationed section follow for offense commit currently as well as independently, such as participation in an organized group with the goal of committing an offense, setting up our criminal group, enabling a person to reside in the Republic of Poland, human trafficking, document forgery, extorting others to submit false statements, the usage of false documents, using, stealing, or misappropriating a document certifying the identity of another person, destroying a document without having the exclusive right to dispose of it. The acts committed constitute offenses against public order and the credibility of documents. Illegal border crossing is usually connected with the commission of other acts. In an organized criminal group organizing illegal border crossing, the roles and tasks of the individual members are structured in a certain way. The leader of criminal group decides on the timing of the smuggling, the transfer points of the migrants to depart, and chooses the border crossing points. a liaison officer between the parties informs them of the success or failure of individual operation, collects the money for individual smuggling, either in person or through an equations of citizen of the party's country, maintains contact with organizer in order to negotiate the price for smuggling, and establish places for handing over the aliens entered. The guide collects the group of migrants at the border, leads them secretly through the border strip, or brings them to the transport. The driver transports the migrants from location close to the border to the designated place of handover the organizers along the route. The pilot of the operation, a driver, is a passenger car, precedes vehicle carrying the migrants en route, providing an early warning system against possible security controls. Analyzing police statistics available from 1999 to 2020, it became apparent that during the 1999s, the number of prosecutions and established crimes was relatively high. Particularly between 2000 and 2005, these numbers were significant. From around 2005 onwards, the number of prosecution and ascertained crimes started to gradually decrease. Furthermore, from 2010 onwards, the number of prosecution and ascertained crimes decreased significantly. Variable conditions such as immigration policy, the situation in neighboring countries, or the effectiveness of law enforcement activities are important. As far neighboring countries are concerned, the crime in question is important in international context due to the cooperation between countries in the fight against illegal migration. Poland cooperates with other countries within the framework of international organizations such as the United Nations, the European Union, and International Organization for Migration. This organization helps to coordinate activities, exchange information, and best practice on migration management and combating irregular migration flows. In conclusion, the presented analysis of the perspective of Polish criminal law in the context of the offense of illegal border crossing demonstrate the relevance of this issue in the face of global migration and border security challenges. The provision of Article 264 of the Penal Code is a cornerstone in the fight against the previously discussed violation of the law. Adopting a proper interpretation of the moment of border crossing and the elements of the crime allows for a better understanding of its essence. It's worth emphasizing that organized action to facilitate illegal border crossing are treated particularly harshly, taking into account the involvement of third parties. Polish criminal law effectively responds to this challenge, providing appropriate legal tools to combat this crime. So thank you for your attention and interest in this topic. I hope that both this conference and my presentation will contribute to deepening our knowledge of current migration challenges. Thank you so much.
Yes, thank you very much for your presentation. And unfortunately, we are slowly approaching to the end of our conference. The last but not least presentation is Professor Erika Varadicheva.
Thank you once more for the possibility. This is really a great honor for me. And I would like to ask your help that I would like to share my presentation. But now is not, this isn't a possibility for me. Or maybe?
If
Yes, okay. Maybe it's good. Do you see?
Yes, we can.
It's very good. It was more easier that I think. Okay, so once more, my short thanks and thank you and this toast to you. And in my presentation, I would like to say some words about the special effects and consequences of immigration and the earlier processes of the intercultural problems in the different societies. So the title of my presentation is The Public Violence and Radicalization, and I have a sentence and a question that this is really new forms of juvenile delinquency, or there are new phases of these problems in the last time. I think so that if I would like to create phases or stages of this process in connection with juvenile, I have to build three different time or phase. The first is the so-called shock effects in a traditional framework, because from the 1980s or 90s, we could observe different processes in connection with juvenile delinquency and juvenile crime. The first was the girls' crime, or not only the increasingly processes of the girls' criminality, but especially the violent criminality, because until this time the young girl took part in the criminality very rarely, and their proportion was already 10% or a little bit more, but not among the violent perpetrators could we observe or detected these activity or this perpetrators group. But in this time, or from this time, there are very bad maybe or very interesting processes in connection with this, and it was very interesting that new form of not only the violent offenders or the number of women, young women violent offenders increased in this time, but the so special form of criminality, then, for example, the gang or girl gangs could we observe it at this time. Some is the queens or stars or hit girls, for example, and these groups, women groups, young women groups, characterized by the large or big cities in Germany, for example, or France or Spain, and they groups or gangs fight it against others groups, and the conflicts strongly interwoven with ethnicity. So it means that Turkish, for example, or North African origin was very important elements of these violent crimes. And the second process or second feature of this time was that the school violence or the violent crime in the schools increased, and parallel with this, the ethnicity became more important than earlier. Between 1990 and 1996, the proportion of juvenile and young adult defendants of so-called non-German nationality with non-first generation. It is very important. Immigrant backgrounds increased to 95%. It means that the violent activity or the activity in connection with the violent crime of this second, third generation was more intensive as the first generation use. And but if we or if the researcher focused only the first generation use violent crimes, they could observe that after 5 years residence in, for example, in Germany, it was enough that the violent crimes ratio 2-3 times higher became than earlier. The second special stage of this part of criminality could so named, or I give this name, that stepping out on the streets. It means that from the 2000 or from the beginning of 2000 years, the violent crimes became more observable as earlier because two parallel process or phenomenon could be observed. One is that the gang warfare. It means that this based on the ethnical sources or roots, and but these are traditional or forms of traditional crime. For example, violent against property or violent activity in connection with drug. So not very special, absolute traditional crime, but the ethnical connection or contact is very important. And the second is was the so-called collective violence, street riots, vandalism against the common enemy. It means that this crime wasn't committed against different ethnic groups or gangs, but against the majority of the society, against the police, etc. And we can see that in this time through 3 years, 4 years long, in first in every important or large European cities or main parts could we analyze these processes, and it was very created real fear among the citizens in connection with these perpetrators. What we know that or what are the common characteristics, maybe this collective violence was committed in Copenhagen or, for example, in Paris, but the characteristics were same. The perpetrators, or the most part of the perpetrators, belong to the marginalized groups of the young citizens, or not citizens, mostly living in immigrant neighborhoods. In large cities, it was very often, and we know that the educational or properties or financial or other backgrounds was relative low in these groups or in connection with the member of these groups. And the third part begin in the middle of 2000 years, 2010 years, excuse me, and we can say that this is the stage of the waking up of these groups. We can say new forms of aggression and new groups of young offenders. If we would like to say only some words about this phenomenon or about these processes, we could say that that one part is very important, that the continuing increase in terrorist behavior from this time is characterized by these years, and but not only the behavior, this risky behavior taking to a new level, but the criminal political answer too, because tightening and broadening regulation could be observed in this time. Only some examples, for example, in Austria, there and in connection with terrorism, in these 2 years, from 2014 until 2016, 50 prosecution of children and juveniles for terrorist acts was analyzed, and the perpetrators, or most part, 80% of perpetrators were boys. It's very important that these young perpetrators give the 60% of all or summa terrorist crimes in Austria. And if we see this number from other point of view, it means that the 15% of crimes which were committed by young perpetrators belonged to these terrorist acts. So it is a high ratio or proportion. Very interesting that the most part of these terrorist acts belong to the involved in a terrorist organization, and the most part of the perpetrators were offender of or only help to this organization. But not only the crime committed in Austria increased in this time by juvenile, of course, or children, but about 140 children traveled to Syria, for example, to take part in the fights. In Germany, the situation was similar, like in Austria, but the crime was changed. What typical crime was changed. Hate speech was the most common among the young offenders in connection with this terrorist type, and dissemination of banned propaganda, for example, or use of banned symbols, etc. But the outstanding to the Syria or Iraq with the aim to take part in the fight. It's increased very strong. And France, we could say similar, and in Belgium too, similar processes. But for example, in France, the Islamist connection became more important, like then, for example, in Germany or in Austria. And the last question is that if we speak about the radicalism or radicalization, this is similar like political extremism, or this is a different answers of the social and financial and educational or problems, or the sources or the causes can be found among the intercultural or regional problems. So what means this? The first is that if we speak about child or juvenile, this is different terminology or definition, and it belongs from the source, for example. But if we speak about radicalization, it means that radicalization is a dynamic process. So a process, not only one act, but a process whereby individuals increasingly accept and support violent extremism. And which is the reason? The reasons for this process may be ideological, economical, or personal, or social. So it's wide spread possibilities there are. But if we speak about the violent extremism or extremism, this is an act or acts promoting, supporting, and committing acts which could lead, this is a possibility, could lead to terrorism, and which are intended to protect, this is very important element, racial, national, ethnic, or religious superiority, or an ideology contrary to fundamental democratic principle and values. So if we speak about the radicalization of or the violent activities of young offender in connection with the first, second, or third generation with immigrant background, this isn't a same process and isn't the same phenomenon. And the answers, which direction is the gives the good answer to solve this problem or to prevent this special situation, because the level of the fear feelings is really high among the other part of the society, and there are two very different possibilities. One is on the field of the formal, of course, criminal legal answers, and the second is maybe connect with criminal law, but the aim is for example, reintegration or rehabilitation, and this connect very strictly and strongly to the cultural roots. And it means that so one group of the answers or possibilities answers belong to the under legal field, so tightening tightening regulation. Of course, the increasing number of prison sentences or the use of pre-trial detention is the possibilities. Or, for example, in Belgium, we could observe that the isolation in the prison is very often in connection with young offenders which committed crime, terrorist crime, on one type of terrorist crime. And the preventive measure, for example, exists in France from 2016. This was a legal answer on the problems, criminal risk factors, and criminal activity of the new migrant groups. And for example, in Belgium, there are the so-called evaluation procedure in connection with children, which show the sign of radicalization, or when the parents show these elements or this risk of radicalization. And it means that this is a very strict traditional answer on this situation, but there are another possibilities, the very traditional programs in connection with the criminal procedure or in connection with the crime prevention activities, special training courses, or to solve the problems of the low level of education and financial problems, etc. The second is which is very interesting in connection with the violent crimes, is the use of anti-aggression trainings. We have some good practice in connection with this. Or the very interesting and very useful, according to my opinion, is the German hot seat or the Heißerstuhl anti-aggression training, because they have 6 phases, and they could excuse me, maybe the time is over. Okay, so and this anti-aggression training is very useful, and the effectiveness is high, but it's real question that in a special culture, or in connection with the special cultural or intercultural problems, or subcultural elements, could this solve the problem, and could give a real answer to the young people if they meet once more with their own and violence supported cultural groups. And other example, this is not only in connection with young or adult offender, but in connection with a special group. In Austria exists a so-called Caucasus group, and it means that this activity aims a positive identity reinforcement of one group of Austrian citizens. I don't know you know or not, but Austria holds the 5th largest Chechen population outside their homeland, and it means that is a real high proportion among the Austrian citizens. And for example, in this special program were involved until now more than 30,000 Chechen member of the Chechen ethnicity or group, and it means the fight against the stereotypes in connection with Chechen habitant or characteristics, and to give something about the Chechen culture, history, or religion. And there are, because the prison is from one point of view, the answer, legal answer for the crime committing, but from other point of view, the prison is a risk factor because most or relevant part of the young radicalized offender gave or got this special cultural identity among the prison years. And so there is different answer how can this prevent this risk situation. So excuse me for this long presentation, but I was really very happy that I could take part this short presentation. And thank you once more for your attention.
Yes, thank you very much for your presentation. I would also like to extend my heartfelt thanks to all the speakers for their prepared presentation, which were exceptionally interesting and of a high standard. I would also thank you all for your attention, and I yield the floor to Ms. Agata.
Thank you. Dear participants, thank you very much for all the conclusions, comments, and proposals. It is an honor to be able to organize conferences with a group of people so committed and willing to share their observations on the pressing legal problems of the modern world. I also thank the people who followed us on the Facebook stream. So just let's say thank you very much for today, and see you at other institute events. Thank you very much.
Thank you. Goodbye.
Thank you. Bye-bye.
Bye-bye. Thank you.